Hi, this is Stephen A. Williams, president and founder of the creditrepairshop.com. And in this video, we're going to answer a question here on YouTube. A person saw the video of, I just got a court summons, what should I do? Um, so when you get a court summons, you have to first, you need to read it and you need to understand who is the one that's suing you. In the top left corner or somewhere in the middle, depending on your state, but it's usually going to be in the top left corner. It's going to say the plaintiff and it's going to say you underneath. Now, you need to make sure that number one, the plaintiff, you need to figure out if that's going to be a third party debt collector. And let me tell you the ways to figure that out. Some of the time, well, number one, if it says the company name there, then it's the original creditor most of the time. If it's a company that you don't recognize, then you'll have to read into the summons to see who the original creditor was. And you'll notice as you go through the summons paperwork, they may not get to that until maybe line 7 of the allegations. Now, so once you clarify that, and if you find out that either you did not do business with this company or you had some type of dispute with that original creditor, you're gonna have two ways of fighting this. Number one, if you didn't do anything with that company, then the first thing that you do, you need to notify them that this is not your account, that you were a victim of ID theft. We just finished a summons for an individual uh, that he was going through this for almost a year, back and forth with a debt collector and the original creditor. And he got to us and he said, "It's not me." And I'm like, hey, we hear that a lot, but if it's really not you, I want you to go and file a police report and we will take care of everything else after that. Now, he had a court date set for last week. This company, he had verbally communicated with them, it's not me, it's not me, it's not me, this is not me. They didn't care. Some stuff got delayed due to COVID, and his court date was finally coming up last week. And I said, get the police report, give it to us, and we'll take care of it. We did everything that we told him we would do, and then we sent that information to the plaintiff attorney. We sent it to the original creditor, which is a national bank, and we sent it to the judge. He showed up for his court date last week, and immediately the judge said that your case has been dismissed. The plaintiff attorney and the bank, none of them showed up. He just said your case is dismissed. Uh, and this was due to an account that was not his. Now, let's go but I bring that up because a lot of people do end up getting judgments against them for accounts that were not theirs because they have this mindset of if it's not me, everybody else is supposed to know that it's not me because I say it's not me. And that's not the way that the process is done. You have to actually file paperwork and notify different parties, notify the court, and you have to do this the right way. You have to say it the right way, you have to use the right documentation, and you have to do the right things, or no one will pay attention to you. No one will pay attention to you unless you take those steps. So now let's put that aside. That was a victory. Saved him thousands of dollars. They was about to get this judgment. Even if they showed up and he didn't have this information and he would have said that it's not me, he would have got that judgment placed on him for thousands of dollars if he did not come to us and we did that paperwork for him. Now, let's get to the side where this is your account. You just got a summons, and this is an account that you know was yours. Now, the first thing you need to do is you need to look at who was the original creditor on that account, and if it doesn't state it, And even if it is the original creditor, there's one test that I want you to check out, because this it's not done a lot, but it has been done, is to make sure that the statute of limitations for them to even collect on this debt has not ran out. Because these companies deal with thousands of people, and you never know, your debt could have got put into that batch and it's not even legally able to be collected. So always do that. Do that when you get a demand letter, and you always should do that even if you get a court summons where you were unaware of the demand letter, or you just threw away the demand letter because it looked like a debt collector's letter. Um, then the next thing is that you have to answer the court summons. Uh, each point, they're usually labeled 1, 2, 3, 4, 5, 6, 7, and they some of them I've seen them go into 20s, have 20 points on there, and some of them are as short as having 4 or 5. You have to answer all of those, and even if it's something that is just dumb, like this is your name, or you live at this address, you reside in this county. These are things that they have to actually notate in there in some jurisdictions, because they have to tell the court that they're suing you in your jurisdiction, that they're not outside of it, because in some states it's illegal to do that when debt collectors try to collect. So you have to answer those point by point. Now, the things that you pay attention to, you closely pay attention to, is number one, what is the relationship that they're claiming? If this is a debt collection lawsuit where they purchased it from an original creditor, you want to make them establish all types of things, such as contract between you and them. How did they get the debt? How did your personal information get released to them? Did you give them permission to get your personal information? Did you give uh, the original creditor permission to share your personal information? We are living in this privacy economy where there right now government, companies, everybody is very alert about sharing people's private information. So you want to learn all of that stuff. Now, if you don't, if they, this is something you got to watch out for. They may have the original creditor's name on there, but when you look down in the summons, it's like this, they're saying this debt collection company name. They had this other name in there. And that's what you got to watch out for. And what you should immediately do if you see that is that you need to call the plaintiff attorney and ask them straight up, and send a letter certified. This is serious business, so you need to also send a certified letter to both the plaintiff attorney and the original creditor and say, I want a definite answer on, is this debt sold to a debt collector, or do you still own the debt? Because this is the reason why, is because you're able to fight things a lot different if a third party debt collector took over the debt, because they have to prove all of the information. They have to go further than what an original creditor has to prove. um, with account numbers, with the chain of custody from the original creditors selling it to who. They usually don't sell it directly to a debt collector. They'll usually sell it to these portfolio debt collection companies, and they may sell it or assign it to a local debt collector in your area. With the virtual stuff that's going on now, I've seen the portfolio companies get an attorney, but they're going to be the one that's on the court summons, and because they can do virtual court sessions as long as they're licensed to do business in that state, and so they've been doing that. But regardless, you have to respond to each allegation in there, and if like, calm down, don't get emotional, and if you just read through it, your own logical common sense will give you ideas on how you can break this whole thing down and break their arguments apart, because each point that they put in there are actual allegations against you. So they may say something like, You owe us $17,561.21. And you come back and you say to yourself, I did have an account with this company, but I don't know how you're coming up with that number. Excuse me, coming up with that number. Let me take a drink here. How you're coming up with that 17,000 and some change number. And so what you do is you ask for complete records of that. Now, if it's a third party debt collector, they will not be able to get all of those records. They're going to just have a few statements. But you have a right. When someone is making an allegation to you, you have a right to push it to the limit on making them prove that whole $17,000. I want to see the charges. I want to see my signature, either written or digital, that I was the one that made these, approved these transactions. Because I do not recall that amount. And what usually ends up happening, this is what usually ends up happening, is that they'll either dismiss it, it'll either put you in a very, very good position to either have the case delayed, or it will put you in a very, very good position to have a settlement agreement, because they know it's one of those things where it's like a deadlock where they know you're going to have to pay something, but they can't prove the whole amount. They don't want to risk going all the way to court, because if they go all the way to court, they could lose 100%, and this whole thing is all done and over with. And what I've seen happen now is that they're starting to threaten to go through a jury trial. They're saying that they don't want to have a judge take a look at it; they want to have a jury look at it, which scares people for some reason, but it should not scare people, because you could actually make a very good case in front of people that that are your peers, and say that this amount does not make sense to me, and I just want to have a true record of it. You can get in front of a judge that might just say, hey, you owe it, and I see it their way, and this attorney is always in front of me all the time, and I just know that he crosses his T's and dots his I's, or she does. So it could go both ways with a judge, but when you have it, and it can always go both ways with a jury, but I think that this is just a tactic that they're using to scare people, because people are like, okay, if they have me in front of a jury, and now I'm going to be scared, I'm going to be nervous, I don't know what I'm going to say. When all you have to do is, when you have your responses to their summons, is that this is what you want your answers to be. They bring you into court, they're going to say, what are your answers to all of the allegations that are on here? That's what they're going to stand by. I mean, really, they make it easy for the attorneys. These are usually junior, like lowest level attorneys that go into court for debt collections. And they're basically following a script on all of them. That's why when someone challenges them in court, usually they may either say that they want to have it dismissed, or they need to have another hearing so they can bring the higher level lawyer that knows more about this in the court to argue your specific case, or they'll just dismiss it. But they're thinking that if they scare you and they say, okay, you're going to be in front of a jury, we're going to request a jury trial, that you're going to be all scared and afraid of that, when it's just people just like you and me, all of us, even like them, sitting there, and they're going to listen to what their allegations are, and then they're going to listen to what your responses to those allegations are. And just imagine if you're in front of a jury and you say, I recall having an account with them. I had an account with them, but I don't have all of the documentation to prove this amount that they're claiming right here. And I believe that in your reading from your responses, I requested all of those documents and they didn't provide it. What do you think your chances are of winning when that happens? So you have a very good chance, but let me tell you what it comes down to. It comes down to this in life, is that how tolerant are you of taking chances, of confronting fears, of fighting through. This is where the breakdown happens. The paperwork is paperwork. It's the individual, and this is what companies like these. This is what debt collectors. This is really the game that they're playing. Is that they want to find out where your tolerance level is, because if they can push you past your tolerance level to where you will shut down. That's what they want you to do. It's really easy for them because they're used to people shutting down at the beginning. They're not used to people pushing them to the end, pushing them to the end. So really, when people push them to the end, they actually break down and quit a lot faster. A lot of the people, I think over the last few, yesterday, two different uh, from the summons that we did, two different ones came through where they dismissed it. One, they got the judgment, but they got the judgment because the individual, she didn't show up to court. So there's nothing for the judge. How can the judge ask you any questions about what you put in the response when you don't show up? So they get a default judgment. And when we looked at the paperwork, it said she said I lost, and I was like, send us the paperwork. As soon as we looked at the paperwork, it said default judgment. That means you didn't show up to court. So this is what you have to do if you're going to win or even have a chance to win any type of civil court summons that is at a debt collector or even original creditors coming after you for. So I'm going to end the video here. I have the links if you need help with a court summons response. I have links below, and we can help you out with it. We'll review it and we'll tell you up front when we get your order if we can help you or not, or the different things that we can do. I used to say if it's a third party, I mean, if it's a direct lender who's suing you, that we would not take those. But I would still like to review them because in certain circumstances, like what I just mentioned with the other gentleman earlier that won this week or last week, that in certain circumstances you can win once we know the complete story. All right, if you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different. If you can follow that process, we invite you to become a customer. If you need your credit reports and scores, everything starts there. Visit the number 3scores.com. Get those reports. Stay with that service so you can always have an upper hand on knowing everything about your credit reports. That's on your, or everything about your credit. That's the huge benefit. If you need the statute of limitations, cease and desist, collection activities letter, and the debt validation letter, those letters are for free below this video. This is Stephen A. Williams, President and founder of thecreditrepairshop.com. Thank you for your time.